In a historic ruling, the Nakuru High Court this week granted a father custody of his two underage children. The ruling goes against the long-held principle of tender years, which preferred the mother to have the custody of children under the age of 10. NTV's Bridget Ngana spoke exclusively to Alex Ndegwa's lawyer on the ruling that could change how custody cases are decided.
The first application we did.
Kavraj Kaur represented Alex Ndegwa, the father of two boys aged 14 and 9 years, at the Nakuru High Court in an appeal by the boys' mother Sylvia Musyoka, contesting the custody granted to Ndegwa by the Children's Court. Ndegwa sought the Children's Court's injunction barring Sylvia from traveling with the children outside the country. The children are American by birth, but have been living in Kenya with their father since 2015, and their mother wanted to relocate the children to America, where she currently lives. The courts here considered the children's opinion, a rare occurrence.
Under the common law, children were always taken as properties. They were not taken as human beings, and as such, all property used to go to the male, and in this case to the fathers. Courts would previously not consider the circumstances of the case. They would not look at what exactly is in the best interest of this child. Is the child more happy with the mom, or is he more happy with the dad? They would not take that into consideration. And they would also disregard the fact that even if you give the custody to the mother, she just simply doesn't want to take care of the child. They would disregard that completely. And as such, children have really, really suffered. So I believe it's time to change that now.
While making the ruling, Justice Professor Joel Ngugi outlined Section 83D of the Children's Act, which considers the ascertainable wishes of the child when deciding custody matters.
So we have principles such as the wishes of the parents, we have the wishes of the relatives, we have the customs and traditions of these children, and we have religious backgrounds, amongst many others. If you look at this particular case, you'll realize that all these were quite suitable to the children here. I mean, in terms of religion, they had a strong religious background here. They were going to church and all that. Looking at customs and traditions, obviously, your customs are where your roots are, and that would be Kenya for them.
The ruling has set a precedent for future custody cases, but has been met with mixed reactions from the public.
To a certain extent, children should be with their mother. But if the fathers are best vested to take care of the interests of these children, then why not? I mean, we talk about equality of women in all spheres of life. Then why not in parenting? Why should parenting be any different? Just because you're a mother, it doesn't mean you're entitled to a child fully. I mean, the fathers also have roles to play. And to be honest, we see a lot of fathers that are now coming forth and they do want to be part of their children's lives.
So hata hiyo maneno tunashangaa sana, ama palikuwa corruption ama nini, kwa sababu kitu kama hiyo tujaisikia Kenya. Sheria ilikuwa imesema 18 years and below wakae na mzazi mama. And above, hao ndo watadecide kama watenda kwa baba ama watenda kwa mama.
Chako ni chako. Mimi tulikosana na mama, lakini hatukukosana na watoto. Kwa hivyo mimi naweza sema ya kwamba pongezi sana, angaa sasa hata sisi boy child, Mungu asifiwe.
Kama mama amewachana na baba, mama wa kambo azilea watoto vizuri, atawatesa, na hii maneno wa mama tumekataa hii maneno. Na hii maneno sio mzuri.
While making his decision, Justice Professor Joel Ngugi said the courts did not consider the financial muscle of either of the parents. Instead, they followed the recommendations of the children on which parent they preferred to live with. Bridget Ngana, NTV, Nakuru.